right. Good morning or good afternoon, depending upon which time zone you're in. I see a lot of familiar names in the lobby. For those of you who don't know me, I'm Mike Lockerbie, a litigation partner in Foley's Washington, D.C. office and chair of the Distribution and Franchise Practice Group. We're pleased to be continuing the webinar series with the Swedish American Chamber of Commerce, SACC, of Washington, D.C., of which our office is a member, and the House of Sweden, the Swedish Embassy, also happens to be our next door neighbor on the Potomac River. Many of you may have joined us previously in the spring and summer. We had sessions on dealer litigation and the supply chain. Those are available online. And today's presentation, of course, is about U.S. government investigations and enforcement actions. And in some ways, of course, that can be any company's worst nightmare, but we have two experienced practitioners who can help you anticipate what to expect, how to deal with it if it happens, and how to hopefully prevent it to the extent that's possible. And that would be David Simon, who's a partner based in Milwaukee, and not only chair of our Antitrust and Competition Practice Group, but also of our government enforcement defense and investigations practice with respect to international transactions in particular. Sitting beside me here in DC is our partner, Olivia Singelmann, who is also a member of that practice group and particularly experienced with the Foreign Corrupt Practices Act, which is of concern to U.S. companies doing business internationally, which is almost everyone. Before we get started, though, I also want to welcome a special guest that you see on screen, Johan Lundqvist. And Johan is an intern with us for the second half of the year, recent law school graduate, and is helping us in the DC office and firm-wide. And SACC's leadership from the DC office is actually in Chicago in a meeting all day. So Johan is king for today and is going to say a few words about SACC, and then we'll be on with the program.
Thank you, Mike. Yes, welcome everyone to the webinar. My name is, like Mike told you, I'm Johan Lundqvist, and I'm representing the Swedish American Chamber of Commerce. For those who don't know, the Swedish American Chamber of Commerce is a nonprofit organization with 20 different chapters across the U.S. And we have now existed in the U.S. over 50 years, which is amazing. And our role here in the U.S. is to increase the business relationship between the U.S. and the Swedish companies. And we are so happy to be able to be a part of this webinar. And if you're interested in learning more about the Swedish American Chambers and what we do, please feel free to reach out to me after this webinar, and I'm happy to talk to you. And yeah, thank you, and I look forward to this webinar.
Start. As Mike said, my name's David Simon. I'm a partner in Foley's Milwaukee and Washington, D.C. offices. Both Olivia and I today we're going to kind of go back and forth. We both have a lot of experience representing companies before DOJ and other regulatory agencies, although we're going to focus a lot on DOJ because that's where a lot of the action is at the moment. So our agenda is up on the screen. We're going to talk briefly about the current state of DOJ corporate criminal enforcement, and then talk about DOJ expectations for corporate compliance, and we'll explain why that's really important, why that matters. And then talk about expectations for companies who are cooperating in DOJ investigations. And we'll also talk a lot about why that makes a big difference for companies who find themselves in front of DOJ and what DOJ really expects to see. These are areas where we find particularly our non-US clients are often surprised at just how aggressive and frankly intrusive DOJ can be. DOJ behaves differently than most enforcement authorities around the world. And so we often find, we represent international companies a lot, and frankly, US companies as well. We often find that there's a pretty significant gap in expectations. And so part of our goal today is to sort of close that gap and make sure everybody who participates in this has a pretty good sense of what this looks like should you find yourself in front of DOJ in an enforcement action. So let me start with just a kind of a quick overview of the current state of DOJ enforcement. It's active and it's aggressive. I would say as a preliminary point, particularly for non-US companies, the US has a long established tradition of corporate criminal liability. Not true everywhere in the world, of course. That's actually an initial maybe gap in understanding for a lot of non-US companies, that in fact companies can be prosecuted and are prosecuted every day in the US. And there is criminal liability, which takes the form of fines. DOJ also prosecutes individuals in a corporate criminal context. So they have been very clear over the last several years that remains a priority. DOJ takes the position that the best way to deter corporate crime is to prosecute corporate executives, and they are eager to do so. So it's very common in these situations to see parallel proceedings where DOJ is investigating a company and its executives over an issue of corporate criminal exposure. And sometimes they charge both, sometimes they charge one, sometimes they charge the other, sometimes they don't charge either. And so that's sort of the big picture paradigm. I wanted to talk just briefly about sort of what we're seeing in terms of trends and priorities from a subject matter perspective. So I think the biggest, the areas where we're seeing the greatest activity are in, number one, national security and trade, number two, antitrust, and number three, Bribery and Foreign Corrupt Practices Act. That's where, those are all priorities for DOJ, have been consistently over this administration. The issues around national security have been a particularly high priority for DOJ, and that includes sanctions, export controls, customs and import related enforcement actions. There's a lot of attention being paid to the issues that are driven by national security concerns. Russia sanctions are obviously a huge focus and continue to be a focus of DOJ. Antitrust has been extremely aggressive as well, both from DOJ and the companion agency, the FTC, have been extremely active. And of course, FCPA and bribery is always sort of an old favorite of DOJ. DOJ has a big infrastructure of prosecutors that are focused on these cases and continue to bring these cases. One note on just sort of where we are in the calendar year that I think affects how we think about DOJ enforcement and probably should affect how you think about it as well. Number one, we're near the end of the government's fiscal year. So U.S. government fiscal year ends on September 30th. There has been over the years increasing focus by DOJ on statistics and being able to report successful prosecutions by the end of the year. So our practice is very much gearing up to hear about a lot of settled or resolved enforcement actions in the next couple of weeks. So don't be surprised if there's if your email is filled with updates and reports on big DOJ actions. The other thing, some of you may have heard that the U.S. is having an election in November. that is also having an effect on DOJ. We are hearing and seeing a number of prosecutors in various divisions of DOJ who are leaving the agencies to go out into private practice. That is very typical in an election year, and you typically will see around an election of some turnover in DOJ. Depending on the results of this election, that could be more dramatic this year than in normal years. If Trump wins, I think you will see more people leave than you might in a normal year. And you may see different priorities from DOJ. This isn't a like new administration kind of webinar. We may Mike want to do that in February or March, depending on the election results. But I think you keep in mind that the election is coming and that it impacts DOJ. And I think maybe this year, regardless of who wins, it will impact DOJ. But particularly if Republicans win, I think you'll see some pretty significant changes. I wanted to talk briefly, and then I'm going to turn it to Olivia, about sort of the corporate enforcement paradigm that is emerging from DOJ. And we're going to get into the details of this throughout the talk today. But it's, to me, very interesting. You're seeing a number of different policies that are being unveiled and implemented by DOJ. And I think they're all driving towards sort of a vision of how DOJ views its sort of corporate criminal regulatory function. And what you're seeing is a paradigm where DOJ is promoting pretty aggressively more transparency and more, voluntary disclosure of misconduct within corporations. There are a number of policies that they've enacted that promote companies' voluntary self-disclosure of misconduct, and maybe more importantly, new policies where they're rewarding insider whistleblowers who come forward to DOJ reporting misconduct by their organizations. And that's creating there already were incentives in place, but that's creating incentives for a lot more of what happens, historically internally in a corporation to become known by DOJ. And when that involves criminal conduct, creating, much greater exposure. That has been combined with some very, I think, strong incentives and rewards to companies for self-disclosing, cooperating, and remediating. We'll talk about that in a lot more detail in this talk. But it's a much more transparent environment that DOJ is trying to promote. With that, DOJ is also grown increasingly confident in its sort of ability to make judgments about companies and and decisions they make. So DOJ is maybe, compared to 10 years ago, much more comfortable saying, management has made poor decisions around compliance, has bad controls, has a bad culture of ethics and compliance. They're very assertive in making those kinds of judgments and judging the companies on how they are doing. They're also very aggressive in terms of their expectations around a company who's cooperating in a Department of Justice investigation. So again, we'll get into this in much more detail, but we have this sort of two sides of the same coin: more transparency, much higher likelihood that DOJ is going to find out about things that are happening inside companies, and much more assertiveness by DOJ in terms of making judgments about those kinds of decisions. So more on that as we go. Olivia, I'm going to turn it to you on the expectations for corporate compliance programs.
Thanks, David. Hi, everyone. So we want to spend some time now talking about kind of the evolving expectations for compliance programs. And, as David has mentioned, this is particularly focused on DOJ because there are some very clearly stated expectations set out by the department that we think it's important for companies to understand. both because, this is something you can use as a resource without being in any sort of enforcement proceeding and hopefully helping to prevent you from ever getting there. But then particularly if you were to find yourself in that situation, to really understand what the expectations would be around remediation or what, a good compliance program looks like in order to, engage with DOJ on that subject. Sorry, I'm having an issue advancing. Here we go. All right, so, initially, we saw in the U.S. federal sentencing guidelines, Chapter 8, Sentencing of Organizations, these 7 elements of an effective compliance program listed out as sort of the way that you could define, what that would look like. And so, standards and procedures referring to some sort of code of conduct or ethics policy, governance and oversight, what kind of compliance officer, compliance committee do you have, education and training, pretty self-explanatory, regular trainings, the types of trainings, the topics covered there, monitoring and auditing, which I think we'll talk about a little bit more. You can't just have the program, you have to test to make sure it's working well. So whether that's an internal audit or a risk assessment, a peer review, some way to see whether things are actually working in practice, reporting out about these things, and then internal enforcement and discipline, that there be consequences regardless of who the employee is. One theme I think we'll get into is, what role compensation plays as one of those potential consequences. And then, of course, the response to any issues and prevention, so that there be some sort of hotline or way that the company can know about issues so that it can timely respond to them. So those were sort of the 7 things laid out in the sentencing guidelines that gave the public a sense of what would be considered effective. And so then in 2012, we got to the FCPA resource guide, which was a joint SEC DOJ publication. It identified what it thought were the hallmarks of an effective compliance program. And this then became adopted throughout, not just the fraud section, which deals with FCPA, but other DOJ sections, Antitrust, False Claims Act, so that'd be civil fraud. And I think you'll see that as also a trend. The fraud section has a pretty robust infrastructure on some of these things, and increasingly in the past couple of years, you'll find that they've really pervaded not just to other sections of DOJ, but U.S. attorneys' offices as well. So now we had 7, now we have 10 hallmarks of an effective compliance program. And just to point out, I think kind of some of the expansions here, we see commitment from senior management being emphasized. So the concept of tone at the top, which I'm sure you've all heard about. But then also third-party due diligence and payments. So, that you can't stop your look at compliance with who is technically working at the organization, but also who you're doing business with and who is kind of essentially acting as an agent of the company. So due diligence, knowing who you're doing business with in advance, but also then keeping track of how they are making payments on your behalf and how they are controlling the spend that ultimately could be attributed to the company. And then also M&A due diligence and integration, which, as you'll see, also continues to be a theme. Compliance has to be something that you're considering in any sort of acquisition or merger. And then also when you're, bringing the parties together at the end, how does compliance look at the end of that transformation and making sure that it doesn't get lost in the shuffle. So that's also a very key part of this compliance infrastructure. So then we got some additional guidance that was actually initially geared internally for DOJ prosecutors to use. This was the evaluation of corporate compliance programs, and it was supposed to help inform decisions that prosecutors were making when they were deciding to charge or kind of figuring out how to resolve these types of cases, But, obviously that then became very useful for companies to see as well, like what they were thinking. So again, you could sort of prevent yourself from getting in that situation or mitigate, and meaningfully negotiate settlement. So there were lots of different questions. They were organized by the hallmarks, and they, addressed a wide range of issues under the compliance program. So even more kind of information points that you could use to figure out whether your compliance program stacked up. So then this was more formalized. It wasn't just something on a website. A couple of years later, we got this evaluation of corporate compliance programs document. And we've had 7 to 10 hallmarks. Now we have these 3 fundamental questions. Is the corporation compliant program well designed? Is it being applied earnestly and in good faith? So you don't just have sort of a paper program, that this is actually something that you are using consistently and really trying to use as the benchmark for how you're dealing with different situations. And then does it actually work? Going back to that testing and monitoring aspect of it. So we pulled out some of the questions that DOJ will ask, kind of that you can learn through this documentation. I won't go through all of them here, but just some to point out. The compliance budget is something that DOJ will look at. So really, that can be a cost center, but it is something that the government will think about it will, assess like what are the dollars being put to this in terms of you being able to defensively say that the compliance program is adequate. Also, that the compliance professionals are engaging with the board of directors and an external audit, that they have an audience with them, that there's an understanding of what's going on with the compliance function, and that the board of directors aren't just kind of, head in the sand on what is going on with respect to that. I think they've also asked specifically about measuring the effectiveness of training. So not just having it, but meaningfully thinking about, whether you see that it's making a difference, that you aren't having a bunch of issues and then have employees say they had no idea these were issues when there are people who have certified that they've completed a training every year. Maybe it's the types of topics they're being trained on. And then I think also another key here is for any sort of investigation, that the company didn't just sort of say it investigated issues, that there's these questions about scope, independence, appropriately conducted, and the documentation of all of that, I think is really key to think about. And this is one area where I think even if your outside counsel aren't conducting an investigation for you and it's being done in-house, that there's, maybe it's a conversation you have with those counsel about, thoughts that they may have on how to scope and document, delegating from the in-house counsel's office to internal audit, just all these sorts of kind of procedural things that that the government really does get in the weeds on. And so just if that wasn't something that you were already thinking about, you can see that that's also of the type that the government is interested in. And so then most recently, we have this evaluation of corporate compliance programs. Existed prior to last year, but was revised again. They say that it's been updated based on their experience and feedback from the different communities. So it's still, we're still in this 3 fundamental question world. But you can see, as we were sort of alluding to, there's some compliance themes that have evolved here. And so again, adequate incentives for compliance and discipline for misconduct. Compensation is going to be something that plays into that in terms of, I think that's like the subtext there. And then also in terms of discipline, I think sometimes thinking about how to communicate that, it can be difficult at the conclusion of some sort of investigation sometimes to be able to tell everyone in the company exactly what happened and how it was resolved. But I think thinking about making sure the expectations of the company in terms of what conduct is and isn't is acceptable is communicated, and then lessons learned type of communications depending on the severity of what occurred. All of that is something that needs to be thought through, and you can see through these recent revisions is something that the department is paying close attention to.
And just sort of to wrap up on compliance, whoops.
Yeah, sorry, I just one more quick thing. And then I just, no, actually go ahead, David, I'll just give it to you. Go ahead.
Okay, sorry.
That's good.
Just to sort of put this in context as we wrap up on compliance. So just understand that if your company is in front of DOJ on anything, that at some point in that process, you are going to be asked to come in and present to them on your corporate compliance program. So all of this, as Olivia said, all this matters a lot just in terms of good governance and protecting your organization from things going wrong. But I just want to highlight the importance of, if you're in front of DOJ, you're going to have to explain and justify. And it matters a great deal to DOJ in terms of how your company will be treated if you can show you had a good compliance program in place and whatever went wrong in spite of that program, not because of it. And that goes, and just, in terms of DOJ's, just to get back to a theme. So this is an area where DOJ has grown quite sophisticated, as you can see from the guidance that Olivia just described. They're really in the weeds, and they're really gotten really smart about it. I think they're experts on corporate compliance. Their guidance is really quite good. If you look at the documents that Olivia just showed you, I think it provides a very clear roadmap for what the expectations are. But you will end up, your organization, if you're in front of DOJ, you're going to end up in front of a team of people whose job it is at DOJ to assess corporate compliance programs. And they'll ask a lot of these hard questions. So one of the areas where we've seen a lot of companies go wrong and sort of fail to measure up to what DOJ expects is a lot of companies have strong cultures, good codes, good policies, and we hear this a lot. Like, we have core values that are ethical and promote compliance, and this wouldn't, nothing like this would happen in our company, and that's just A, not true, and B, not satisfying to DOJ. DOJ, in terms of assessing your compliance program, really is going to want to focus much more heavily on the process, procedures, systems, and controls, not on the value and the culture is super important. But DOJ, as they always do, looking at things with the benefit of hindsight, say, well, something went wrong, so obviously that wasn't good enough, right? That's why you're here. That's why you're in the fraud section in the conference room presenting on your compliance program. So their focus really tends to be, assume someone doesn't buy into your culture, violates your policy, ignores your code. What systems do you have in place to prevent them from violating those policies and breaking the law? And this is where procedures, controls are really important. And so don't neglect this. This is an area where your internal audit teams can really help, because they think a lot in terms of controls. What kinds of approvals and systems can we put in place to prevent things from going wrong is really important. Then I will say, Olivia made this point too, but I think it's the second most important thing, is testing and auditing. This is a big emphasis of DOJ. You can do everything right, but if you can't show them you're checking to make sure that your policies and procedures are being followed, that your training is being effective, that you're looking at your approval process and making sure people are following it, or your third-party intermediary onboarding process to make sure people are following it. If you don't do that, you're not going to get full credit for having a good corporate compliance program. So Olivia, I'll turn it back to you. So the flip side, compliance is one pillar and then cooperation is the other. As I said before, I think this is an area that frankly shocks a lot of our clients when they are in front of DOJ and they decide to cooperate in DOJ's investigation. It can be jarring how aggressive DOJ is in its expectations of companies.
Yes,
so
exactly.
I'm continuing, aren't I, Olivia? Sorry.
That's okay.
Let me sort of start by the framework and the policy. So there are two different policies from DOJ that sort of address this. It started off in the FCPA space, but now it has been, as of 2022, extended to all of DOJ divisions. And they have what's called a corporate enforcement policy, which you can look up online and follow. It's pretty clear. The basic paradigm is if a company voluntarily self-discloses misconduct to DOJ, if it cooperates in DOJ's investigation, and if it effectively remediates and fixes the problem, essentially, there is a presumption in place by DOJ that you will not be the company will not be prosecuted. So it's a pretty powerful incentive that they lay out. If you do, those three things, you are not going to have a criminal charge brought against the company. I should caveat it with, it only goes so far, right? It only binds DOJ. It doesn't bind the SEC. Doesn't mean you won't, if you're publicly traded or otherwise subject to SEC jurisdiction. Doesn't mean you're not going to be hit with an SEC enforcement action. It doesn't mean you're not going to be hit by an enforcement action or prosecution in a different country where there's cross-border activity. And it doesn't mean that DOJ won't prosecute your executives individually, because they might do that. But the value, I think it's obvious, the value of not having a criminal prosecution, criminal charges brought against the company is pretty significant. We can talk. I just want to briefly address the first element, which is voluntary self-disclosure. There's a whole sort of guidance and line of thinking around what does that exactly mean. DOJ expects voluntary disclosure to be prompt and truly voluntary. So the nuances of this are probably subject of another webinar. But if you want to take advantage of these benefits of the corporate enforcement policy, you need to get in pretty early and be the first to bring this to DOJ's attention. If there's press reports, if there are whistleblower activity, external whistleblower activity, you jeopardize getting this credit. So element number 2 is cooperation. And this is where we're going to focus the next section of the webinar. Cooperation with DOJ is super important, whether you're within the framework of the corporate enforcement policy or not. It really drives heavily the decision on charging the corporation. So if you cooperate, you have a much better chance of not getting charged at all. And I just put this slide up because even if you're not within the corporate enforcement policy kind of rubric, cooperation by a company can really impact the fine that the company might be subject to in a corporate criminal proceeding. So it's almost always in a company's interest, once they're in front of DOJ, to cooperate with DOJ's investigation. So let's talk now about what that entails. So this is just from the corporate enforcement policy from the Justice Manual. They provide some details about what cooperation means, what they think cooperation means. So these are just some of the highlights. They want to see an independent investigation by the company. They want all the facts from that investigation shared with DOJ. They want, in international cases, translation of documents. They would like you to make witnesses available if they're under your control. They essentially expect you to act a little bit like a deputy DOJ prosecutor, right? So you are sort of running an investigation into the facts of the misconduct and providing essentially the results of that investigation to DOJ. They don't typically ask to invade attorney-client privilege, so they're not going to ask about lawyer conclusions or legal advice. But in terms of the core facts, they really expect you to dig it all up yourself, for one thing, and then to share all of that with DOJ. This is just a little bit tongue-in-cheek, but there is this sense of they won't ask you for things, but they lay out their expectations very clearly, and the consequences may be staying, unstated. But like our friendly mobsters here, it always reminds me a little bit of, nice business, pay us your protection money, or it'd be a shame if something bad happened to it. There's always that sense with DOJ of there's a risk that, if you don't do what they want you to do, they're just going to charge you. And then you have to deal with all of the, frankly, horrific consequences of having criminal charges brought against the company, which is not fun. So what does this really mean? Olivia, I'm going to turn it to you to sort of talk about what some of the specific things we've seen, some of which have frankly been surprising in terms of expectations and asks of DOJ from our clients in this context.
Yeah, so we start out by saying that cooperation is not for the timid. I think we always say to people before, we try to go over this cooperation aspect when advising on whether we think a self-disclosure should be made, because it is really a lot of work, and we kind of often describe it as one of the most painful processes that you could go through. And I think when I go through all this, you might say, well, why would we voluntarily offer this up if this is all that we have to do? It doesn't feel like we're getting much of a break here, understanding that some of what you have to do to cooperate also incurs cost to the company. But I think, just as David was saying, there is such an emphasis on voluntary disclosure at this point, and I'll go into some kind of our third phase, some even further developments there, and just the increased risk that someone would tell DOJ before you would, especially with increased international cooperation. Keep all of those things in mind as we sort of talk about what it means to cooperate. So you really have to take a proactive posture. That means, the request might look something like, what do you think is really key? Identifying hot documents, making presentations. You're providing the government with all of this information, but they want to hear from you about what, your independent investigation has uncovered and where it would be most helpful for them to look. Expansive document requests. I think at this point, I don't know that lately I've gotten like a request truly to just turn over an entire email inbox. And I think that is in tension with the next point, that the government wants you to do the work for them. But that might look something like, well, can you look for documents among these 30 different people? Because they all occupied this position. And so, we think that's important. Or increasingly devices. I think the biggest thing I've seen over the last 10 years is that it's not just email anymore. It's really, and it's not just laptop, it's phones, especially with, messaging apps like WhatsApp, and depending on what country, you're operating in, that is where a lot of key communication really takes place. And, that isn't as easy to collect as just remotely pulling, emails off the company server, but there is this expectation that you'll do that. Again, doing the work for you, that can look like translations of documents. I think one of the things with translations, especially, I think previously there was a little bit more of an argument to stand on that was really something that was very burdensome to do. You had to send documents out, you had to pay for a translation service. But now there's a lot of technology kind of built into document review platforms, and it really is fairly inexpensive and easy, depending on what kind of document it is, to translate some of these things. And so depending on the size of a document production, it is kind of like pushing a button. Obviously, there are times where the translations are better or not, and I think it depends on the language that you're in. Translating a different alphabet, I think, with machine translation provides some additional challenges. But kind of when thinking through, your initial instinct might be, well, this is so much work or so much cost. Technology is kind of making some of these things, I think, a little bit more reasonable. And so you'll have to think through that when the government asks for those things. Summaries of data, again, as David said, not necessarily asking you to waive attorney-client privilege, but to the extent you can provide facts that you learn in a non-privileged context, or, especially if there's like a forensic accountant involved and there's been some quantification of data from a factual basis, expected to share all of that. And going beyond asking just for employees or people in the company's control, providing contact information for third parties, if there are former employees who are willing to cooperate, making that request, as it might come easier from the former employer, depending on the relationship. And then specific attribution, and I think this goes to this expectation that it's not just the company paying a large fine or something anymore and having things resolved, that there really is an expectation that you say exactly who knew what when, because those individuals could also be prosecuted, but the company can't really shield those people if it expects to get cooperation credit, expects to have been considered to remediate an issue. And then, again, that can sometimes look like a download of employee interviews. I think this is one of the biggest attorney-client privilege tensions. There are ways that you can try to insulate the privilege, not providing the actual memo, providing highlights. I think there are people who would say, well, you're still waiving the attorney-client privilege there, which could be an issue if there were ever like a shareholder litigation afterwards. But, I think you have to weigh the risks of all those things, but just be prepared that that is something that will come up in thinking through cooperation. As David mentioned, it really is kind of this deputizing defense counsel. The government will tell you that they are not directing you to do anything, that they aren't telling you how to run your investigation, but there's this, the mobster picture subtext that they're really asking you to do this, and you really need to do it if you want to get the cooperation credit. And I think that can sort of challenge what it might feel like to you to be, in a defensive posture. You want to find out the information and speak to who you need to get that information, but the government might ask you to go first, and they may say, at this point, we really want to get that information before you do, or you can't read in counsel for any individuals under investigation. I think it just really probably depends on how the government views that individual, because I do think it is kind of standard to do some of these things, but they may ask, and you'll have to weigh how strongly you feel about that, and remember the potential consequence of being seen as not cooperating. Employee screens, David and I have dealt with this, and if it seems like anyone in counsel's office was not even necessarily involved in wrongdoing, but just aware of something of a past issue, they may ask to screen off, and that can just be a logistical headache. But the government may feel very strongly about it, and even if you push back, you may decide that's something you have to do. I think employment decisions are another really tricky area where, maybe you want to get rid of an employee. It might just be a routine reduction in force at this point, and you don't think these individuals had anything to do with the underlying conduct, or, they, maybe they did, but there's a separate issue now that's come up. You do have to, it's best to really engage with the government before you just remove people from your control. And they may say, well, we need to interview that person first, or we need to hear from you about what you've learned about them, or ask you to interview them, even if you feel like, there's nothing to be gained from that person. They didn't touch the issue. So these are just, some of the things that I think could maybe feel less obvious, or feel like there's power being taken away from you in terms of driving an investigation that, when you're in this posture, you will have to work through. And I think we've kind of talked about privilege. And the one area I think where you would probably want to consider a waiver, or it may be harder to push back on, is if there's an attorney involved in the actual misconduct. There have been cases where there are, in other countries, it's a lawyer who's making payments or acting as an agent, or involved in something like that. And, even though they're an attorney, those documents and information related to their work is really central to what went on in educating the government. And you may want to engage in a waiver in that context, and then think about how you can set it up to be as limited as possible to continue to protect the company as much as possible. So again, just kind of thinking you might feel a little off doing these things, but as we've said, the benefit as David sort of walked through with the credit that you get really can be significant. So there's been recent guidance on cooperation credit. Again, the good thing, I guess, is that you're not in the dark about what this means. And David already showed some snippets of, the types of things that are expected. And so, they'll lay out, like the bolded text in the first bullet, that it's really, you're supposed to be providing all non-privileged relevant information related to all individuals involved in the misconduct. They want to know how quickly you're providing the information, it's not just that you're offering it up, but that you've done it quickly. And I think there were some developments, I think it was last year, about, this, I forget what the phrase was, but very, very, very quickly making this type of self-disclosure, and that would be seen as extraordinary, and that you might get even additional credit for that. I think we haven't quite seen how that has worked out, but underscoring, and there's no definition for how quickly that timeliness is, but it shouldn't be multiple years kind of thing. And that's for sure. And maybe, you may just need to move very quickly with these things. And then, just prioritizing what information you're providing, not just everything you've learned, but what you think is really key about what kind of who was involved and what went wrong there. So in terms of, how much is enough, I think it's probably more than it was before. So, the good news is there are clearly laid out expectations in press releases about corporate resolutions. There's often discussion about the specific things, we're declining to prosecute based on a number of things, including the company's cooperation. It may even outline what the company did to cooperate. So you're not in the dark here, but I think what we're seeing is that if you look at, and there are writings about this, if you look at older corporate resolutions, like the things that they did there probably wouldn't qualify for the same amount of, reduction as what is actually happening now when you look at companies getting those same credits and what they actually have to do. And obviously you have to take into account the underlying misconduct, but, fully cooperating it's definitely not trending the other direction at this point. So again, just something to keep in mind. Yes, and we've got the graphic for you there. So I'll kick it back to David about this timely and appropriate remediation, and then I'll close out with some recent kind of pilot developments.
So just one last thing on cooperation. I think in terms of expectations, it takes a long time to get through one of these processes with DOJ. I think the average, I mean, I know FCPA the best. I think the average FCPA matter from sort of beginning to resolution is between 3 and 4 years. I think multiple years is sort of the typical cadence for this process. Our clients are always frustrated by the speed of DOJ. And we always are trying to push it along to try to bring things to a close, and it's always frustrating because we can't move them faster than they want to move. So, just in terms of expectations with DOJ, it's going to take a while, and it's going to be really expensive. I mean, there's just no getting around it. There's a ton of work that needs to be done, and it takes a long time to do it. So, the third element on my corporate enforcement policy, we had self-disclosure, we had cooperation. The last piece is remediation. And so this sort of overlaps with general compliance program considerations that we talked about at the front end of this, but it's more tailored to remediating the misconduct that got you in front of DOJ, right? So this is really sort of driven by an analysis of the root causes. So DOJ wants you to say, okay, something went wrong and we're fixing it. And you don't need to worry about this company being in front of you again, because that's what remediation is about. So again, sort of focus on the root causes of what went wrong, put in new controls and procedures targeted to those particular causes. And then overall, a lot of this, you see these other points that are highlighted here are focused on the compliance program generally. And what's your culture? What are your systems? Do you have a reporting system? Are you disciplining employees for violations? Are you auditing and testing? All the things that Olivia went through before become a part of this. But this is also part of the corporate enforcement policy, assessing, did you remediate and do you now have an effective corporate compliance program? So M&A, back to you, Olivia.
Yeah, so we just wanted to go over 2 last sort of recent developments in the overall, corporate enforcement kind of policy realm. So one was, almost a year ago, an announcement about a new safe harbor policy for voluntary self-disclosures in an M&A context. And so that basically, taking some of the guesswork out, okay, there's a presumption of declination if an acquiring company engages in, prompt and voluntary disclosure, and that's specifically within this 6-month safe harbor period. If they cooperate with DOJ's investigation, they've gone over cooperation, and then this engaging in appropriate remediation. So it's, it's basically taking the voluntary self-disclosure, but putting it in an M&A context. So then there, this applies department wide, so it's not just any one division. It's important to note, as David was talking about remediation, this misconduct has to be fully remediated within a year. And then you'll note that there's a specific call out to national security misconduct, that has to be reported immediately. And I think if you were to read the kind of announcement that was made about this policy, national security came up a lot. And I think this just goes to show that this is an area where the DOJ has been really focused. It's devoted a lot of additional resources to national security, and it started couching some areas that we wouldn't have thought of in that way, tying those issues in. And so here, in the M&A context is another example. I think possibly a motivation behind, it's the voluntary self-disclosure, but also, hey, look, here's another aspect where another way we can get at the national security considerations. And then finally, we've talked a lot about voluntary self-disclosure and how that's encouraged. This year, there was a whistleblower pilot program launched. It was launched officially in April, but we've heard about it, kind of coming. And it sets forth some specific criteria that an individual can qualify for a non-prosecution agreement. And there's qualifying criteria laid out here, but there are certain individuals who are not eligible. So, a CEO or a CFO engaged in wrongdoing, the organizer or the leader of the criminal scheme, any appointed or elected public officials or of domestic offices, law enforcement, and then individuals with prior felony convictions related to, dishonesty. So here, given the increased incentive for whistleblowers, it's really important to make sure that your whistleblower policies are kind of up to snuff and that you've got whistleblower protections in any internal investigations, that you're, reiterating that the company doesn't retaliate, because there's just going to be more scrutiny on whistleblowers, given that there are now additional incentives for individuals to come forward to try to qualify for a non-prosecution agreement. And so that's all we've got on the slides. We're happy to take any questions, or David, I don't know if you have wrap-up remarks.
And the questions, we don't have any so far. If anybody wants to type it in, now's the time. But while we'll give you just a minute, but while we're waiting, I just want to wrap up. Maybe wanted to just say, look, that this is being in front of DOJ is no fun. It's one of the really the worst things that can happen to a business organization, in my view. But there is a path forward, and you need to be patient. You need to be prepared for some frustration along the way, but there's a path, and if you do the right things and make the right decisions, you'll emerge from it at the end intact, maybe a little battered, but intact. So I think, Elizabeth, we don't have any questions. If there's any last opportunity, if anybody wants to.
Actually, David and Olivia, I do have one, since there are none from the audience. And in the interest of full disclosure, the answer to this question could probably easily consume another hour-long seminar, but at least wanted to plant the seed and get your brief thoughts on this. As a distribution and franchise lawyer, I was especially interested in the potential liability under the FCPA for the activities of dealers, distributors, and franchisees. And I was wondering if you could simply provide an overview of the extent of such exposure, and also what, if anything, companies can reasonably do to minimize such exposure, even though the distributors, dealers, and franchisees are obviously independent companies.
Yeah,
you're right. Go ahead,
Olivia. So the exposure is broad. You don't have to know or have directed any of these third parties to engage in misconduct on your behalf to potentially be liable for it. But there are things you can do, and best practices. There, having third-party certifications, having code of conduct that applies to these third parties, due diligence. If you can ask for audit rights or things like that, that's not always practicable, but just making it clear that you are proactively doing what is reasonable to make sure you know who you're dealing with, that you're not dealing with someone who's known to have had problems in this area, that you are, you're doing everything you can to know, and that your head isn't in the sand, that if you can set things up so that there isn't, extraneous payments, monitoring any kind of entertainment budget or areas where, money can more easily go out the door. Those are all things that companies can do. And we certainly, that's something we can certainly easily advise on. We have, lots of kind of examples for types of, policies and certifications and language that you can use to protect yourself. I don't know, David, if you have anything else to add.
Yeah, no, that's exactly right. I'll leave you with this, Mike. I think more than 9 of 10, probably 95% of FCPA actions over the last 10 years have involved actions by third-party intermediaries, including distributors. That's that's where the problem arises, and that's where the prosecutions come from. So it's an area to definitely pay attention to.
Great. All right. Well, again, thank you both, and thank you to our audience. I hope that you will join us in our future webinars, and also a reminder that we do have coming up in Chicago on October 23rd, the 33rd annual Law of Product Distribution and Franchise Seminar, which is a day-long program, and you can attend either live and in person in our Chicago office or via the web. So thanks again.
Thanks, everyone.